All right, welcome. We good? We start? Good? Very good. Oh, wow, 3 classes left, right? Wow. Where the heck did it go? Hopefully everyone's not sick of me yet. We have a little bit to go, a little bit more. Let's see, any questions, anything in your mind from last class? Anything lingering, anything bothering you? No? Okay, then let's get started. In our last class, we started the First Amendment, the freedom of speech. We will continue freedom of speech today. On Thursday, we will do the freedom of religion. 1 class is not nearly enough. That's all you get. And the final class, we'll talk about the Second Amendment, which is a nice place to finish because it's a very good overview of how our Supreme Court operates. We discussed in our last class one thing that's both easy and infuriating about the First Amendment. It applies to use of scrutiny. And it uses words you're familiar with. For example, strict scrutiny. You've learned that before. But what drives students absolutely batty is that it doesn't mean the same thing. Strict scrutiny doesn't mean the same thing for due process, equal protection, and free speech. It has different meanings. Okay? Rather than speaking of fundamental, non-fundamental rights, which is what we have in due process, instead we speak of protected and non-protected speech. So one of the unfortunate byproducts of having these tiers of scrutiny is the court tried to lop it on to free speech in ways that doesn't always make sense. And this is particularly confusing because you've just figured out just now what the difference is between due process and equal protection. Now you have this other stuff called free speech. Okay? So in our last class, I tried to sketch out as clearly as I could a way to approach free speech cases. This is not going to be foolproof, but I think it'll get you through what you need to know. So try to follow along as best as you can. You'll recall with due process, right? The first question we always ask is, are we dealing with a fundamental right or a non-fundamental right? Remember this? For example, if it's in the first amendments, first 8 amendments to the Bill of Rights, or something like a contraceptive or something, right? These are deemed fundamental rights, which are entitled to heightened scrutiny. If it's a non-fundamental right, economic liberty or whatever else, it's given rational basis review and the government wins. There's a similar analysis for free speech, right? So you have to ask yourself, is the speech in a protected category? Is the speech in a protected category? Often people will just say, is the speech protected? But to more precisely, is the speech in a protected category? And in large measure, the Supreme Court has divided different types of speech into different categories. If it's a protected category, it gets some scrutiny. If it's not, it doesn't. So first, what happens if it's not protected? It's not in a protected category. Okay? When you're dealing with a type, this is just a review. We did this last week, so if you're not sure, raise your hand. When you're dealing with a non-protected type of speech, it receives basically no scrutiny. The government can ban it. When you're dealing with a speech that's not protected, that's receive First Amendment protections, it makes sense. The government can ban it, regulate it however it sees fit. What are some examples of these? I listed a couple. Libel and defamation. We did the New York Times or Sullivan case, right? Obscenity and child pornography. I'm sure as many of you should know if you don't. Possession of child pornography is not speech. It's illegal and that can be banned. We did the fighting words case. Remember, this was a case of Chaplinsky, the guy who called the police officer a damn fascist or a goddamn racketeer. Right? These are words which make you want to punch someone in the face, whatever that means, right? I mean, we all have different angers, like Hulk, make mad, right? But invariably, these are words that make you mad. These are protected. The final category, which we'll discuss in the last case, the Brandenburg case, the Ku Klux Klan case, is unlawful incitement to violence. These are words which basically are so infuriating and so passionate that they drive people to go engage in some some act of violence. That's the Brandenburg, the KKK case we'll do at the end of class. Last case today. Okay? We first have to ask yourself, oh yes?
You're talking about the scrutiny and how you have to separate it from the equal protection and all that. You used an example that under the equal protection or the rational basis with age as far as
Yes.
driver's licenses.
Yes, that's not a protected class, yes.
How is that? How can that not be applied? I understand you're looking at the First Amendment, but how can that analysis not be applied in this first case about the video games when it comes to they're just restricting it to age groups?
So I didn't want to get to that case yet, but let me answer your question quickly. Are they restricting to age groups, or are they restricting the type of product that can be sold? In other words, is it regulation on children, or is regulation on the gaming manufacturers to put this labeling system on it?
It's a labeling system, but it's saying that children shouldn't be.
Okay, so the short answer is, if you're the gaming company, right? How would you rather argue this case, as an infringement on speech or an age classification? Why? And how is age protected? That's the right answer. But primarily, it's about the regulation of the gaming company. We'll get to this case in a few minutes. Yeah.
Unlawful incitement to violence is the same as true threat?
No, true threat is slightly different, and I admit it, but I can put it here also. True threat is like a cross burning, right? The purpose of a cross burning usually is to threaten people, to intimidate people, right? Maybe people say they burn crosses as a cultural experience, whatever else, right? But the purpose of the cross burning is to intimidate or threaten people. Unlawful incitement of violence is using words to rile people up, to get them to go and do something bad. We'll do that in the last case, but there's a subtle distinction. It's not a big distinction. I'm sure many Klan rallies that do burn crosses, right? So it probably blurs together, but they're different categories of unprotected speech. Any questions so far? All right. So the second question says, okay, if it is protected in a protected category, okay, then you get scrutiny. And I'm not going to say what kind yet because it depends. I'll just say some scrutiny. It varies, but for now, we'll say some scrutiny. Details will come later. Okay. So here I listed, what, 5 or 6 different categories of unprotected speech? What are the categories that are protected? The answer is everything else. The answer is everything else. Unless something falls in these 5 or 6 different categories, protected. The presumption is that all speech is protected unless it falls into one of these narrow categories. So whether it's political speech or artistic or literary or musical or whatever other thing you can think of, it's speech. That's protected. The only exceptions are very narrow, these 5 or 6 things. And one of the lessons we learned from the Brown versus EMA case, the violence game that Whitney mentioned a minute ago, is that the court is not interested in recognizing new categories of unprotected speech. They haven't recognized a new one like in 20 years. So effectively, this list, I can't say this too certainly, but this list is probably going to be the complete list of what's unprotected, unless Supreme Court changes direction, which is always possible. Okay, everyone get it so far? Any questions on this? This is not a 100% test. As you can tell from today's reading, the court has gone all over the map. Why burning a flag is okay, but burning a draft card's not? We'll talk about this, but the court has not taken a consistent path on speech. So it's somewhat infuriating to students. But this will more or less get you in the right framework. and right frame of mind. Any questions before we get started? Yes. I'm sorry, say that again. I didn't hear your question.
Okay, thinking about that. Did you hear about that rapper that got like 25 hit sentence because of his lyrics?
Well, didn't his lyrics confirm that he committed a crime? No, what wasn't that? Didn't he brag about committing a crime in his lyrics? Wasn't that it?
I think it was gay.
Yeah, if I understand it, he was convicted, charged with a crime, and the evidence was his own rap lyrics.
Oh,
Well, I mean, but there's an interesting First Amendment question. I read about this case. So here's the deal: the guy was on charge of some sort of crime. I forgot what it was. So if anyone remembers, raise your hand. Sarah, do you remember this? Well. No. This is a very good thing. Can you prosecute someone, one at a time, Sarah, one at a time. Can you prosecute someone for a threat in a poem or a song? The case is called Elanis. This was a case this year at the Supreme Court where someone in a Facebook rant, he called it a poem, whatever he wants, a Facebook rant, threatened to kill someone. Can he be punished for this speech? He claims his artistic license, same way Eminem talked about murdering Kim, right? It's actually really tricky questions. Can someone be convicted for speech they have in a song? Lil Wayne's been in jail already, so. So actually, you mentioned Lil Wayne. This is actually true. So I'm a Lil Wayne fan. So there was actually he was actually deposed, right? He had a deposition on something, and basically you can watch the video on YouTube. It's hilarious. He says, "I don't know every single question," right? And there's one question that said, "Were you ever in jail for having a gun?" And the answer is yes, right? He's like, "I don't know," right? So there's actually a lyric in one of his songs where he says, "Like the gun I went to jail for." So could they have used that lyric to bust? Anyway, totally unimportant. You mentioned Lil Wayne, so I will. All right, let's talk about Brown v. EMA. See, originally this case was Schwarzenegger versus EMA, which is such a better name, but Jerry Brown became governor almost at the last minute and had to change the party. It's been a much better case of Schwarzenegger versus EMA because no one would have ever forgotten that Arnold Schwarzenegger was trying to punish violence, right? No one would have ever considered that the governor of California, the governor, right, was trying to suppress violent video games. I mean, but unfortunately now we have just Jerry Brown, Governor Moonbeam himself. Yes, perfect. Michelle, the law that California tried to enact here. What did this law do?
It prohibited like the sale of violent video games, and it required a label, I think, for 18 or
Okay, so two things. Did it actually prohibit it, or did it regulate how these games are sold? Okay, good. How were these video games sold? Violent video games sold?
They were, I think, supposed to have a label on the package.
And what if someone's under 18? What would need to happen to buy the game?
They would have to have like adults.
A parent. It's actually a parent or aunt or uncle, and as Justice Scalia knows, any adult who pretends to be, because there's no verification method to actually prove that the person who's with them, it's like, someone buys you a rated R ticket to movie theater. Remember, I'm sure someone did that for you at some point. It's supposed to be parental supervision, but the guy at the movie theater is not going to check if it's your mom or dad or whatever, right? So California says we have this problem. We have all these young kids playing these disturbing, violent video games. Let's pass this law. Are required to put a rating system on the game, and if a minor wants to buy one of these games with his rating system on, they need a parent or some person over the age of 18 to accompany them, right? Maria, what about rating systems on video games now and rating systems on movies? Why are those okay? Aren't there, rated E for everyone? You see that? Aren't there already ratings on movies and ratings on video games?
I think that those are made by the video game.
Yes, they're voluntary. Who here knew that the ratings of video games were voluntary? Did everyone know that? I didn't know that when I started this case, whenever this was years ago. Whenever you go to a store and you see, rated N, was it N, or I don't know what the ratings are, right? Those are voluntary. Industry, upon their own initiative, said, we will put these ratings on these games. Okay? Same thing if you go to a rated R movie or a rated whatever movie. That's what we always see the Motion Picture Association of America. This is a private organization, so they self-regulate the movies. This would be something different. The state would be effectively saying, we will determine based on our definition of what video games are violent. We will define violent if it has, murder, dismemberment, rape, whatever. They have an entire list of categories. And if your game has any of these characteristics, you are now required to label it with this age rating. Everyone get what the law does. Okay. So Adela, what did the EMA, the Electronics, or was it the Merchants Association, the video game lobby, what did they argue that this law did? How did they approach this law?
Well, they argued that it was free speech, and that they were protected when they were pursuing to produce violent video games.
Wait a minute. How is a video game speech?
Well, they said that.
Wait a minute. Okay, so let's actually make this point very clear, right? I'm talking to you right now. You and I are talking. Are we engaging in speech, right? Okay. If I were to, write stuff on the board, is that speech? Okay, so if I, for some reason, a marker all here, right? Right? If I draw something, is that speech? Okay. Okay, if I start singing, which I won't do, would that be speech? If I write a poem, would that be speech? If I write a graphic novel, would that be speech? If I design Pac-Man, right? No, right? Would that be speech? If I design a video game where people are robbing cars and raping people, is that speech?
They argued that it was.
Do you think it's speech?
Yeah, I mean, it is a form of communication.
Okay, so Adela is right on target. Okay, that's my idea of drawing, right? The Supreme Court has taken the position that virtually anything with expressive content is speech. It doesn't matter the form or medium you choose. If something has some form of expressive content, it's speech. So if I make a video game, or I write a book, or I write a poem, or I sing a song, or I draw on the marker on the board, or whatever it is, right? The court has taken a very broad view of what speech is. So the First Amendment applies to just about any type of expression. So there's really not much of a doubt here that a video game, which is really, if you think about it, a bunch of code, right? I mean, this is not like someone actually taking a marker and drawing a cartoon. These are people, developers with sophisticated code, writing many, many lines to make this video game. There's interactions. You do this. You press buttons. I'm terrible at video games. I have no idea. I was always never good hand-eye coordination, right? So all of these instances are cases where people are speaking on a computer. Okay, so there's not much of a question whether video games qualify for First Amendment protections. The valid question is this a type of speech that warrants protection, right? Are we in one of our categories of protected or unprotected speech? So, Whitney, let me ask you this question. Is speech that has a lot of violence in it, and you can read through Justice Alito's concurring opinion for details, but, video game people getting dismembered, their guts getting cut out, people getting raped and murdered, and the worst things imaginable, right? Is this protected speech? Not apparently, is it? How is this type of speech, which, does this speech have any value to society? Does this speech offer any positives to the human race? And I'm talking about teenagers here, which is not a very good specimen of the human race, but in general. I shouldn't say that. Adults play video games too. So then why is such speech with such, you know, depravity and disgusting stuff, why should that be considered protected? Oh, I know they said it's protected, but why? Oh, I know that. I know, but why doesn't it? Why can't we make new categories for this type of violent speech? I'm trying to get the question, which you're definitely trying to avoid. What? Just because the court labels something as protected, it doesn't actually matter. The reasoning is why did it get there, right? Tiffany, I'm sorry, Cindy. Why is this type of speech given any protection if it's so terrible and offers no value of any literary or cultural worth? It's disgusting stuff.
I think they wanted freedom of expression, and because it's not a valid reason.
Ah, yes. This is a lesson which today's generation of millennials don't understand, right? Offensive speech is still speech. The mere fact that something's offensive or disgusting doesn't mean it's not worthy of speech, right? But the question is why? Why, Cindy? Why is something that's offensive not worthy of protection? This is
Well, I guess everybody perceives something different.
Yes. So if we were to start saying that offensive speech is not protected, who would be deciding what is offensive? Exactly. For them to say, for the justice to say, I find this speech offensive, I'm not going to protect it, that's the court injecting their own view of what good speech is and what bad speech is. This is the legislature saying, we think this is good speech and this is bad speech. The government is then the one deciding what ought to be protected and what ought not to be protected. What's the problem with that, Jocelyn? What's wrong with when courts and legislatures start deciding what speech is worthwhile and what speech is not worthwhile?
Yeah, I mentioned there was a quote where he said it's like kind of dangerous when you try to restrict speech because then you get into the realm where you're trying to. He said where you're trying to distinguish politics from entertainment, and it gets really dangerous then if they're deciding that, well, we don't like what's being said here, and they might just as well say, oh no, you can't say that about the legislature. So,
Good.
no, we're not gonna
Very good. So the lesson you have to learn from this case is that there's a risk when the government starts picking and choosing what speech is good or not. There's a risk when the government says, oh, this is offensive, but this isn't. Why? Because maybe they'll use that authority to stifle political speech they disagree with, as Jocelyn mentioned. Because maybe they'll say, we don't want these video games involving, this type of crime. Maybe we won't want video games involving guns. Maybe we want video games involving who knows what. But there's a risk that people in politics will inject their own views and they will stifle expression that's not conducive to their views, that doesn't support their views. So the Supreme Court has taken the position that unless something falls to one of these few categories, the risk of suppression is so big, the risk of suppression is so great that they can't even mess around with this. Okay? Yes? Okay, so obscenity, obscenity is defined as having absolutely no social value at all, and it's very offensive. The problem is the obscenity doctrine existed in a time gone by. The court hasn't upheld anything in the obscenity law in like 30 or 40 years. I don't know if it still exists anymore, right? So I list this category, but I do so with caution because it hasn't really been applied in 30 or 40 years. There have been virtually no obscenity prosecutions during this time. But to give you an example, certain types of really, really gross pornography at one point, scatological, those things were deemed obscene. Today, And the reason why I just shrug my shoulders is because obscenity is based on cultural standards of the time. Obscenity doctrine came out before the internet. We have the internet today. I don't think anything is beyond cultural norms at this point. And I don't say this as a joke, but to answer your question honestly, that is basically a dead letter. And it was never argued that these violent video games are obscene, because the types of things they show, even if it's pornographic or they involve murder, would not be obscene anyway. right? It's not really bad pornography. In case you really want to know, remember a video called Two Girls, One Cup? That's not obscene. Anyway, so I'll leave you with that. You asked. I was thinking about either. That was the only example I could think of. They were considering prosecuting the producer that for obscenity, and they ultimately didn't because it wouldn't stick. Anyway, don't Google that. Do not Google that. Good. If you're annoyed, don't Google it. Christian, you happy? Okay, now you're happy. Okay. You had to ask. So, where was I? Yes. The mere fact that something is violent or offensive, the court says, doesn't mean it's not worthy of protection. Okay? So, Jason, is violent media for children new? Is it some sort of brand new phenomenon that video games invented, that there was never any violence for kids?
And that's what Justice Scalia pointed out, is that it's not just video games, but we can't restrict kids from ideas. Like, there's also ideas and other things that they're going to be experiencing. He's like, it sets a dangerous precedent if California restricts video games. And what's next? Are they going to restrict kids from being exposed to ideas?
Yes. So, have any of you ever read the Brothers Grimm, the fairy tales? Not like the cartoon, the original ones. They're pretty gruesome, right? You know, people getting chopped off, put in ovens. Even Hansel and Gretel, you get the kids throwing the witch into the oven. If you read Oedipus and various other Greek mythology, you see some really messed up stuff. And yes?
I wanted to discuss that point. Where I was reading that, the whole thing I was thinking of is that there's a difference in a child's mind when they're reading about something versus when they actually visualize it.
Who says that, in the opinion?
Well, I mean, no, I'm saying I was thinking.
All right, but what did Justice Breyer say about that? I mean, Justice Breyer makes your exact point. I'll get there in 2 minutes. I'll get Breyer, okay, I promise. So Scalia is saying, listen, there's nothing new about dangerous stuff. If you have a really good book, who reads anymore, right? But if you have a really good book and you get really engrossed in it, it's the most realistic thing in the world. You get drawn into this alternative world. What does Scalia say about all these studies, which Demi mentioned a moment ago? He's like, well, you know what? They may show causation, but they don't show blah. They may show correlation, but not causation. Do you know the difference between causation and correlation?
Causation means that they played video games and that caused them to go violent.
And what's correlation?
They just happen to play.
Okay, so the number one fallacy, the number one logical fallacy you see anywhere, and this drives me nuts, okay? You have a line. There are more violent video games. Children are more violent. They're both going in the same direction. Therefore, it must be that the video games cause the violence. That is what's called correlation. The fact that you have more video games that are violent and there's more violence in children, they're correlated. They're in the same direction. But that doesn't mean that one causes the other. There's no causation that violent video games cause children. And as Scalia points, it's very hard to isolate in the life of an 18-year-old child what caused them to be messed up. Okay? It's very difficult to isolate in a person's entire childhood between parents and school that there's one factor of violent video games attributed to this violence. Can this ever be proven? I mean, people are psychologists for their entire lives and they still know what's wrong with them, right? So Scalia is saying we can't extrapolate that to an entire society to use this as a compelling interest to stifle speech. Now, and this is Demi's point. Justice Breyer replies, wait a minute, we have all these studies and studies. Breyer's wife's a psychologist. I'm sure he had some extra help with this one, right? These things are not an opinion, right? Justice Breyer says, wait a minute, we have all these studies, right, that show that children's minds are impressionable. That there's a difference between reading a book about bashing someone with a baseball bat and taking a Nintendo Wii and swinging the little nunchuck, right, and actually bashing someone's head in. And Breyer says, frankly, I'm not willing to second-guess these experts. I'm not willing to second-guess these psychologists and these legislators who had testimony and they determined that these games are bad for children. Right? Sean, how does Justice Scalia reply to all these statistical, studies and surveys? What does he reply to this?
Scalia's argument that's come back for a long time, and every generation can point to anything that's happened and say, well, that's going to take us down the path. Oh, the world's going to end because we're having comic books. Mm-hmm. Or, oh, we've gone to movies, so now the world's going to end. Yeah, and it happens over and over again. But the second foot never fell.
Yeah. Scalia's argument basically is, so what? So what? we're applying strict scrutiny here, right? We're applying effectively something called strict scrutiny here. Jason?
It was Justice Thomas's dissent that really got me.
We'll do Thomas in a few minutes, okay? Not Thomas Scalia yet. Scalia says we're applying strict scrutiny here. With strict scrutiny, you remember, the government has to have a really good interest to limit individual freedom. They have to have a really, really good reason to limit individual freedom. In the context of equal protection, remember we discussed what are your interests? National security and Korematsu, right? Right? Something of the highest order. Okay? Nephi, what is the state's interest here? What is the state's interest for this California law? What are they trying to achieve?
They're trying to protect children from being exposed to certain things.
Is that an interest of the highest order for the majority?
I feel like it should be. Making sure your kids are morally.
Whose kids?
Everybody's.
So the state is looking after the children of parents. Does the court think that that's an interest of the highest order?
Not exactly.
No, they don't, right? They basically say that protecting children may be important, but protecting them from violent video games isn't. You see the distinction they make, right? Maybe Nephi's right that protecting children is very important, but doing it by suppressing video games is not sufficient. And even so, let's pretend it's important. Let's look at tailoring for a second, right? We always look at means and ends with scrutiny. How are they trying to achieve this, Andrew? What are the means they're using to shield children from these video games?
Just a broad
Yeah.
legislation that requires all children to have games with them.
They're wiping out an entire category of speech for young people. Right? This is not narrowly tailored, as we would say. That even if protecting children is important, it's not narrowly tailored to do it in this manner. Okay? So for the majority, this law flunks strict scrutiny. It's protected speech. This flunks strict scrutiny. Okay? Any other questions on the majority opinion? Yes?
I guess, how would you say that it's not narrowly tailored? Because they're not wiping them out completely. They're just saying we have to have a parent present with the device. And that's like narrowly tailored.
The report says just because you have a parent with you buying it, how is that? The interest isn't you buying it; it's the effects the video games have on you. So if your parents there to watch you buy it, and you go and play the game in your room, how are you serving that interest? It's too high.
3.
So, my friends, the court said that it wasn't necessarily trying to stop every child from seeing it. It was trying
This
to
way,
parent
yeah.
control.
Yeah.
And because what they're doing is, in theory at least, inserting the parent into the decision to purchase it, it gives the parent that control. Obviously, there are ways around it and whatnot. But
Okay. So I thought I could answer all 3 of your questions at once, but I don't think I can now. So to answer the first question, right? What we're talking about here is the government deciding which video games fall in this category and which video games don't. The government passed a very broad guidelines of which video games are covered. This was actually the point that Judge Alito concurred on. These were very vague. So anything involving murder or violence or gore was now involved. When the government starts classifying speech one or the other, that's when they get in trouble. So even if we put aside the fact these are violent video games, that they tried to classify the speech with these categories, that was probably enough to do them in. And that was the point that Justice Alito made in his concurring opinion. So they answer questions number 2 and 3, right? What is the role between this law and parents? Does this law reinforce parental supervision? Or does this law interfere with parental supervision? Caleb, you're nodding your head. I'm not sure which one, though.
Well, it doesn't go to the parents at all.
What do you mean? No, well, the parents have to buy the game for the kid. What's the problem?
There is no way of, it's like exclusive. There's no way of checking whether.
No, but answer the question. Does this reinforce the parent's supervision, or does this interfere with the parent's role?
I would say interfered.
How?
The state's doing what the parents.
Yes, and this is what pisses off Scalia. The state is deciding how kids should be raised and not the state. This doesn't bother Justice Breyer at all. Justice Breyer thinks this is awesome. This gives parents a bypass. This gives parents a way to enforce discipline. But Scalia's like, no, right? What if I'm a mother and I trust my 17-year-old to buy his own video game? Now I need to get the state's permission to go with him? And it's actually a very subtle question to Neffy's point before. Is this actually protecting children, or is it getting in the way of parent raising the kids as they wish?
So my question is, if you want for this law to be okay, it would need to be more narrow. It's too broad. That's one of the issues we're having.
Well, that's what Justice Alito argues. Justice Alito argues that would be okay.
So my question is, if it is too narrow, but then the issue is also that we don't want the government to be splitting like this is good, this is bad, then you can't make it any more narrow because then it would still be problematic.
That's the trap, right?
So what is the
You can't do this, right? So Lauren's question is a good one, right? How could California have made this law more narrow? I don't think they could have. I think no matter what California did, they would run into the same problem. That's why I think the Alito concurrence doesn't really make much sense. He's basically saying, oh, I'm going to uphold this, but I don't like it. I'm going to hold my nose, right? Scalia's like, screw it, right? This is not going to fly no matter how you try. Right? This is not going to work. Alito says you could do this more narrowly. I don't see how it's possible. Once the government starts classifying this speech versus that speech, you're in strict scrutiny land and you lose. Right? So that's the point Alito makes. Alito's like, listen, we shouldn't be so quick to apply these principles without knowing the full effect of this technology. We should listen to these experts, but, you know, this is too vague. I don't see how you make the statute work. Sarah? Sure. Sure. All right. So everyone see just Alito's point, right? He's like, listen, let's not jump into this, but this is probably this video game stuff. This is bad stuff for kids.
So we're talking about limiting video game companies' freedom of speech.
Ah, yes. Corporate speech, my lord, right? We have it again and again. The speech rights of video game manufacturers, Electronic Arts and the like. Yes. Imagine that. No one was up in arms with this case either.
The dissent prior's getting on, or is it Alito's getting to the children's ability for first amendment?
Right. And so let me ask this question to Brandon. Whose speech are we talking about here? Are these the speech rights of the children or the speech rights of the video game manufacturer? The case is called Brown versus Electronic Merchants. It's not called Brown versus Children. This wasn't a case where children tried buying a video game and was not able to, right? This wasn't a case where a child was arrested for buying a video game without a parent. Whose speech rights are we talking about here?
In practice, it would actually try to curtail kids because acting is a stronger force, I guess, for them than just watching.
Let me ask you this question, Brandon. I'm speaking to you. What are you doing? How would you describe this expression?
Verbal, voluntary,
And it goes
mutual.
two ways. All speech is two ways. I guess you could talk to yourself and keep a journal, right? I suppose no one ever reads. But speech involves the creation and dissemination of information. There's actually a case from 2011. Speech is the creation and dissemination of information, both. Right? So the answer to Morgan's question is it's both. It's the right of the video game manufacturers to speak through their games and the right of children to receive those ideas. It's a two-way street. Everyone get that? Justice Thomas, Jason mentioned this a minute ago. Justice Thomas takes a very idiosyncratic view of children and that they have no rights. They have no rights to speak, no rights to be spoken to. They are purely the wards of their children, of their parents. There's a very famous case which was mentioned in the reading called Tinker versus Des Moines School District. This is where a high school student wore a black armband to school to protest the Vietnam War, and she was suspended. And the court said that, I'm sure you know, you do not surrender your first free speech rights at the schoolhouse gates, right? You don't surrender your rights to the schoolhouse. Thomas is like, no, you do. He would say that there's basically no rights of children to any free speech. So Justice Thomas is always very, it's an interesting opinion. If you want to read, he goes back to the common law about children traditionally had no rights, and it's an interesting discussion. but it's Thomas being Thomas. So the interesting dissent is by Justice Breyer. And I think Justice Breyer is probably the most hostile justice to free speech on the court, and probably in at least since like the 1920s. I don't know. It's probably, you have to go that far back. And it's not that Justice Breyer is hostile to speech, but he puts a significant weight on the ability of the state to protect people from their own errors. He is very, very eager for the state to protect people. He loves the state. I mean, I'm sure he wakes up in the morning, he's like, thank God for the state. That's his reason for existence. And how do we help democracy work? How do we help the state flourish? So he sees this case not really about speech and violence, but about protecting children. And he goes through all these studies and meta-studies and meta-meta-studies showing that children are very impressionable, that reading is substantively different than actually interacting and hitting a joystick or a keyboard and blowing stuff up in person, and that this will really screw up kids. Okay, that this will have serious damage. Okay, so Juan, why is Justice Breyer willing to defer to these experts, but Justice Scalia is not? What's Justice Breyer like deferring? Why is that so important for him?
I think Breyer is looking out more for the kids and free speech.
Yeah, but it's not he's looking out for the kids. You're right. He's looking out for the state. And if the state determines that this helps children, and the state determines that based on their experts this is going to help children, that's what he's promoting. So it's not just about the kids. Breyer's driving force in life is how to promote the democratic process. And the democratic process determines that these games should be regulated in this manner. To Breyer, the First Amendment should not stand in that way. Yes?
How do we pose this idea with the shot issue that's going on now?
What shot?
Immunize your children or not. Is that regulated?
Well, I mean, we did this when we did due process. We talked about vaccinations, right? Where generally the state can require you to get vaccinated. That was the case of Jacobs for Massachusetts. That was notwithstanding a due process challenge. So what's your question?
Well, I'm just confused because I thought people aren't, I've been hearing on the news that people are choosing not to vaccinate their children.
Well, a number of states have various exceptions for a conscience. So if you have a conscience objection, you don't have to. Like the state carves out religious exceptions, although under Jacobson for Massachusetts and Buck v. Bell, they won't even have to do that. Does that mean to answer your question about the impressionable minds? Okay, good. I told you to get back to it. All right. So again, the vote in Brown v. May was 7-2, with only Breyer and Thomas in dissent. But Alito and Roberts were somewhat uncomfortable with this opinion. And they joined it because I think they felt compelled by doctrine. They don't like it. And the majority, you have Scalia joined by, Ginsburg, Sotomayor, and Kagan, right? So this is one of those cases where Justice Scalia has become probably the most pro-free speech justice in the court. And he often votes with the liberal justices to promote free speech in different ways. And Kennedy, too, is in the majority. Sorry. And I know it was one off. I was counting to 8. Okay. Anyway, so what does this case say? Basically, we are not recognizing any new categories of unprotected speech, right? The courts, this is what people wanted. They wanted some category of dangerous, harmful speech. Court said, nope, not going to do it. There was one case mentioned in the reading, which I want to mention briefly, called United States versus Stevens. This was a case decided the year before, involving crush films. Does anyone know what these are? Or you want to say? Thank God, you are moral people. A crush film involves women in high-heeled shoes stomping on little animals. Yes. So these films, and don't God today, don't Google this either, right? Love God, don't Google this. It's of course illegal to do this to animals as animal cruelty. What about filming it? Right? Can you film an illegal act? And there was actually a conviction where this guy was distributing on the internet these videos of crush films and DVDs, whatever, and the court invalidated his conviction. It goes vote 8-1. And they said even though the underlying act is illegal, you can't punish depictions of it. Why? Because depictions of violence like this are protected, right? If we can protect video games that are violence, other stuff, why not crushing of little kitties and stuff, right? Yeah.
Well, what about the fact that video games are not real and you're filming in real life events?
It doesn't matter. I could film, right? If I film someone getting robbed or raped, whatever, it's speech. Let me give you one more. There was a case mentioned in the reading called Ginsburg, not like the justice, it's with an E. There was a case from, I think, the 60s or 70s, can't remember the year. And New York passed a law banning the sale of girly magazines, pornos, right? To, I think, people under the age of 15 or 16, can't remember the age. And the court upheld that, okay? So it's illegal for the state, it's perfectly fine for the state to ban the sale of girly magazines to little kids, but not violent video games that have just as much nudity. So that one, we can't wrap our heads around. Yes?
Would it matter if it was the distribution for sale?
These video games aren't being given away for free. They're sold. They're expensive.
If you sell a video, it doesn't be great. That's all.
So I mean, there might be some there might be some issues with a civil matter because the videos are released without the person's consent, but
Not reporting a crime.
yeah, maybe a conspiracy charge involved with the rape, but the actual speech itself. In this case, the guy was selling the DVDs. I don't think he did the actual crushing himself. Yeah.
How do good Samaritan laws make conflict with something like going to rape or something like that? In certain states, do they not have good Samaritan laws where if you're witnessing something?
I mean, if you're the one who's filming it, you were probably involved in the rape and you're going to jail. I'm talking about the actual selling the movie, right?
Okay.
So the movie's already done. You have to make a copy of it.
That makes sense.
Yeah.
Would the difference between the pornography that is actually showing a rape and the difference between a game, the rape doesn't happen until there's interaction. So would that be the difference? In other words,
I mean,
I've never played the game, but from what I understand, you're the one doing the killing, you're the one doing the whatever happens. So wouldn't that be the difference between the ban?
the court said it makes no difference whether you're reading a book, watching a pre-recorded movie, or interacting in a game. Makes no difference.
But in a game, nothing happens until you make it happen.
Yeah, that's the design of the game. That's immaterial for the First Amendment. Doesn't matter.
Obviously, those involved, like in filming and the carrying out of such, like a snuff film, would be prosecuted. What about the sale?
Yeah. So the snuff film is basically basically a snuff film means you're killing someone on the film, right? If you're involved in the actual snuffing, yeah, you're going to jail. But if this is a video that's been around for 20 years and you sell a copy in your video store, yeah. I saw one other hand here somewhere. Alana's hand, yeah.
Yeah, I was gonna ask about that film, the Eric Garner thing. I guess was that not related? Was him being put in jail not related?
Which video are you talking about?
The chokehold death?
Oh,
The cigarette guy in New York?
yeah. I mean, he filmed someone dying, right, in his camera phone, right? That's speech. I mean, it's a matter of extreme public concern because it involves police officers doing it.
Yes.
So yeah, I mean, you can. I mean, there might be some privacy torts if you're filming someone without their consent. That there might be some sort of privacy infringements. But if you're in public, you can record what you want. Lauren.
Can I clarify, so like the point you're making is that there might be other consequences for
Yes,
all these actions.
but you can't be punished for distributing the video.
You're not gonna be punished under First Amendment.
Yes. Yeah, if you're engaged in underlying crime, the First Amendment won't save you. You're actually engaging in a crime. Yes.
Sorry, one more question. So there's no way that is, they're trying to ban like the filming of cops.
Oh, good. I'm glad you asked about that. So this is actually a really interesting topic. Thanks, Crystal. Right. Generally speaking, in most states, it's illegal to record someone without their consent. Okay, it's called a wiretap, right? Remember Monica Lewinsky and Linda Tripp years ago, right? Generally, you can't record someone without their consent. Okay, so now that we have iPhones, people start recording the cops when they get pulled over because people like recording cops in case they don't do something stupid. Cops, I'm serious, started arresting people for wiretap violations. Okay, I actually worked on one of these cases. My friend from law school argued to the First Circuit. I helped him with the briefing on this. There was a cop who was arrested. A woman in New Hampshire was arrested for filming the cop, and the Court of Appeals actually held that you have a First Amendment right to gather news. Imagine that. Recording the police is gathering news. It's actually recording something of public concern. That when you're a police officer, you're engaged in a matter of public concern. You're in public, you can be recorded. The only wrinkle with that, which I think is a serious wrinkle, is that often when you're a police officer, you have to make sure people aren't holding weapons. And if someone's flashing around some sort of shiny object at night, and you might think it's a gun, they're likely to get shot, perhaps. So there's serious training issues that need to be done to ensure that people can respect it, and that people aren't waving cameras. Because all the idiots taking selfies in front of crime scenes, those are potentially dangerous because you need to clear the crime scene. So this is a legitimate issue, but a number of courts have held that you have a First Amendment right to record the police, which I think is correct. But this is still ongoing. What else? Anything else on video games? Yes. No, those laws are not okay. The distribution's okay. The distribution's okay. Pretty much. So there is something called there's something called revenge porn, which you may have heard about, and it's somewhat of a nebulous area, but it often involves someone being recorded with or without the permission, naked, sex, whatever, right? And then someone else distributes that to others. Another number of states have actually created civil causes of action for this, where, say, if someone uses my image without my consent, I can sue them. These cases are on shaky First Amendment ground, but they're not criminal. It's not that the state can punish you. If you're a voyeur or wiretapping someone without permission, there are laws to prohibit that. But if someone voluntarily takes a selfie and sends it to someone else, and then that person distributes it, traditionally that person was out of luck. But some states are trying to regulate this, and they've had varying successes in court. A couple of these have been struck down. Yeah.
There was like a big case with the guy who ran like a big website.
Yeah, so this guy was basically extorting people, saying, unless you give me money, I won't take this down, right? So there's an extortion element there, which is something different. He was trying to basically say, I'm going to put these pictures go online unless you pay me to take them down. So there's a serious extortion, a racketeering element going on. Yeah.
It seems like, I just know at my high school, like a lot of people, that happens to a lot of girls, like they use it to get around to school. And a lot of times, I guess, they just claim, is that not a form of child porn?
So this actually happens. I don't want to spend too much time on this, but if you're a 17-year-old and you send a selfie to your 18-year-old boyfriend, okay, he's in possession of child pornography. I swear this happens. If two 16-year-olds send naked selfies to each other, they are both in possession of child pornography, and states have actually prosecuted them, made them register as sex offenders because they're both 16-year-olds. You are in possession. It's a strict liability offense. Possession of child porn, it's a strict liability offense. This is actually a big issue. Where minors are sending each other nude selfies. People put these online, they put them on Facebook, whatever. You're purveying, you are distributing child pornography. And that is a strict liability offense, and the punishment for that is significant. You're a felon, you're a federal felon. There's not a lot of latitude there. So if the prosecutor brings charges, you're in trouble. Yeah.
If just one person sends it, could they both be arrested for that?
The person who sends it and the person who possesses it. If you have it on your phone, you're in possession. So if someone texts you the picture and you don't even know about it, you don't even know how old this person is, it's a strict liability offense. You're in possession of child pornography.
So delete it.
No, it's in your memory. It's on your cache. You can't get rid of this stuff. It's a very yeah.
It's kind of on the same topic, but something that's always kind of.
All right, everyone, calm down. All right, last question. Then move on to draft card
On the
burning.
same topic, but something that's kind of always bothered me is like, say, the mayor of Houston was driving drunk, or was arrested for driving drunk. Okay, or the mayor of any given system, arrested for driving drunk.
Yeah.
But the facts were inconclusive, no breathalyzer, innocent until proven guilty. But her mugshot, or her mugshot gets released all over the place. and that contaminates, and it kind of distorts that image.
Mug shots are a very difficult situation. So a lot of courts have actually held that a mug shot cannot be released to the public unless there's a actual conviction. So, for example, with the Freedom of Information Act, right, requesting mug shots, generally if the person was acquitted, you can't release the mug shot, but police departments send them out all the time. All right. Okay, let's move on. We have a very good discussion. I want to make sure we cover the rest of our ground for today. Okay? All right, so we have here our framework, right? We first ask, is this protected, and if it's not protected? Okay? Virtually everything's protected. Okay? So the second question I want to ask yourself is it content-based or is it content neutral? What do these questions mean? Is the speech being restricted on the basis of its content? For example, the violent video games are very clearly being restricted on the basis of content. So that if it has, murder, rape, dismemberment, right? There's specific categories. What is the subject? What is the content of the expression? Okay. If it's content-based, it applies something that approaches strict scrutiny, and this is some of a nebulous thing because it doesn't mean the same thing as before, but it's approaching strict scrutiny. Okay. What if something's content neutral? What do I mean by that? Well, say, for example, the city says, if you want to obtain a parade permit, right? If any of you want to hold a parade, you can't just get all of your friends start marching down Main Street. You can get in trouble. You have to obtain a permit. You say, wait a minute, making me get a permit is bad. You are punishing my speech. You're making me, pay for this permit and go through this paperwork. I want to just march down Main Street with all my friends. The state will say, no, wait a minute. We're not regulating the content. We're not telling you can't have a parade for this or that. We're simply saying go through the same process as everyone else. We are neutral to what your parade's about as long as you follow a certain procedure. Everyone get the difference, right? The state isn't saying no parades for St. Patrick's Day. We don't like Irish people. They're not saying that. They're saying if you want a St. Patrick's Day parade, fine. Come to our office, request a date, 6 months or a year in advance, pay the permitting process, right? How do we know if something's content neutral? It's not being regulated on the basis of content, but based on the time, place, and manner of the speech. Okay? This is an overview. I'll drill down in a minute. So the parade example saying, listen, we're not going to tell you what you can say in your parade. All we're saying is, when you can do it, where you can do it, and how you can do it. You can do it on Sunday morning, down Main Street, for an hour with up to 500 people, because that's all of our police department can afford to protect. Okay? They're not directly limiting your speech. They're just saying, do it Sunday morning. We're not going to let you have a parade during the middle of rush hour down Main Street. That'd be crazy. Does this have an effect on your speech? Yeah, a small one, right? I say, you know what? I want to do my parade on St. Patrick's Day, and that's on a Tuesday. They say, no, you're going to do it on Sunday because that's when we don't have any traffic. Okay. So there's going to be some limitation in your speech, but for the most part, it's neutral. It's only respecting the time, place, and manner of the speech. Okay, everyone see that? Yes, Sarah. Depends where. Yes, yes. So if you want to have a massive protest, like maybe in Discovery Green or in some big park, you're probably going to need a permit because you get arrested. So this was actually an issue with, if you remember, kind of debated the occupiers. Remember them? How they would occupy in parks, they would live in parks for months at a time. They had no permit. And had the state wished, they could have arrested every one of them for protesting without a permit. There is an impact on speech, of course, because saying you can't engage in this protest, you can't do this or that. But the state, I think, does have some interest in making sure that public spaces are used in a manner where everyone can use them. So these people are living in the park for months, people can't use them otherwise. So this is where the time, place, and manner restrictions come into play. Go ahead. I'll give you an example of manner, right? So there was a case in Central Park a number of years ago in New York. where a group wanted to have a rock concert to fight against racism, called Rock Against Racism, right? And New York had a law, said, okay, fine, you can have a concert, but you have to use our sound equipment. And they said, no, we want to use our own sound equipment. We don't have to pay for your sound equipment. This was very expensive. And this went to the Supreme Court, and the court said, well, this is fine. I mean, they're not telling you what your message is, simply saying you have to use the sound equipment. And that has a rationale because the park doesn't want people dragging their equipment, rigging it up, plugging in, there might be safety hazards. So the manner in which you speak, the sound equipment is to be regulated.
There wouldn't the value of society be detrimentally impacted?
Well, they can say whatever they want, but they have to use the sound equipment from the city.
But they said that one of the rules was like the actions of the person have to be greater than the value of society.
Right, but that case is applying content-based strict scrutiny, right? The park case is content neutral, which is time, place, or manner. You see, the categorization is important. The violent video game case is characterizing based on the content of the speech. The park case, right? I'll put in parentheses like the park is called Rock Against Racism. It's the park case, right? They're saying you can use our own equipment. I'll give you another example. Everyone know what a sound truck is. Think of like an ice cream truck with a huge speaker on the roof, right? Where instead of playing the ice cream jingle, you're driving through town, blaring a message about religion or politics or God or whatever, right? This group wants to drive their car through town 24 hours a day. Middle of the night, they can drive their sound truck down the street and blast at full volume their message. Can they do this? Well, the city said, I'll tell you what, you can ride your truck from 9 to 5 during weekdays, not on weekends or nights. Does that limit their speech? Yeah, they can't speak at nights and weekends. Is it based on the content of their speech? No, it's not based on the content of their speech. What is it based on? The manner, the time, the place. That you can make this volume of a certain level at these hours. Lauren.
So the video game situation, those ratings, you said they're voluntary.
Now they
So
are.
pretty much everybody who makes a video game because they put a rating on it. That's
Today.
Today.
Yes.
So it's still voluntary. Is it still voluntary?
Yes.
Right. Okay. So could you say that parents, like, could you pass a law, so not a voluntary situation, that required all video games with a mature rating to be purchased with parent supervision, because that is based on the rating, not
That may
on
satisfy
content.
Judge Alito, right? That may satisfy Judge Alito's concern. But don't satisfy Alito's concern. You're still limiting ideas to children. Like that actually might buy Judge Alito's vote if you use a voluntary rating system. But that won't satisfy the majority.
Isn't that the law how it is now, though?
No, there's no law. If a video game store sells you a rated X game, whatever the rating is, there's no criminal repercussions. So if a movie theater sells a minor a ticket to an NC-17 movie, there's no legal repercussions.
So whenever they ask for that stuff, it's probably like a store policy.
Yeah, store policy. They want to look good to the concerned parents, but there's no legal requirements to do so.
Could you argue the content?
Oh, but it's not content neutral. It's based on but let's explain why, right? It says if your video game has murder, rape, dismemberment, it's in this category. That is judging the speech based on its content. No, but that doesn't matter. Are you judging it based on the content? But the question is it based on the content? The answer is yes, right?
When the content is what you're worried about provoking actual action,
All that's good, right? That's all in Breyer's dissent. But the initial question, is it based on the content? Even Breyer says it is. Right? There's no doubt the video game law was based on the content of the communication. But you only get to time, place, matter if it's content neutral. It's not. How is it content neutral?
the content doesn't have any
No, but you're asking the wrong question. The question is it being separated in different categories based on what's in the video game? Yes or no? Are the categories established based on what's in the video game? And then it's content. That's not content neutral. It's content based. because based on the content, you're putting in different categories of violent or not. No, it doesn't. It's actually not. No, this is the least arbitrary aspect of the opinion that all 9 justices agreed on. Right? Whether there's a scrutiny issue, that's something else, but it's not a content-neutral law. It's judging speech on the basis of its content. Okay? So let's talk about O'Brien, the next case, right? We talk here about speech, and I think I asked Adela before, is, writing a poem or singing a song or making a video game. Is that all speech? And Adela, I think, correctly said yes, right? Patrick, what about engaging in acts? Instead of giving a speech, what if I decide to light an American flag on fire? Or what if I decide to take my draft cards, and select a service and light that on fire? Is that speech? Is burning something speech?
Potentially.
What makes it speech?
Whether, like I said, it's expressive conduct.
Good. Okay. So the court has held that various activities, doing stuff, right, such as burning a flag or burning speech, burning a flag or burning a draft card can be speech. Even though it's conduct, it's what's called expressive conduct, right? Expressive conduct. Speech you're engaging in actually has a value of communication. So, for example, let's say I'm having a barbecue, right? And Mitchell, I'm having a barbecue, right? I'm lighting up some coal, and I'm burning the coal. I'm burning meat. Is there any expressive conduct there? No. Okay, now what happens when I toss an American flag on that barbecue? Oh yeah, I tossed on there, said, here, American flag, boom. Is that speech? Is that expressive conduct?
Yeah.
Why? Why is that speech? Why is, having a barbecue, having the coals burning, that's not speech, but toss the American flag in that grill, why does that become speech?
I would say just because people can interpret it differently, people can react differently to it.
Okay, Wade, what do you think?
I think there's a specific message you're trying to convey.
Yes, and that's the important part. It's not how people may interpret it. It's what is the message you're trying to convey, right? In the case of O'Brien, the draft card burner, right? He says, listen, I oppose the war in Vietnam, right? I oppose this war in Vietnam, and I think I think that the draft is like slavery. I think this is a terrible thing. And by burning my draft card, I'm trying to send the message that this is something that we should not respect. The guy burning the American flag, Texas versus Johnson, good old Texas, right? He was at the 1984 Republican National Convention in Dallas. He was walking around saying that Bush and Mondale are murderers, they're going to have nuclear holocaust, and he takes an American flag and he burns it, he lights it ablaze, and he's trying to say that this flag represents evil and it's bad, and we should not respect this symbol. So they're not speaking, right? If he had gone up, let's see, Marianne, if O'Brien had gotten up on a soapbox and said, you know what, the draft is evil, we need to, and we use the phrase, fuck the draft. There's another case called Cohen v. California. Said, fuck the draft. Could he have been prosecuted for that? Just saying, fuck the draft. Okay. What if he had gone up in a soapbox and said, you know what, fuck the American flag, I hate it. Could he have been prosecuted for simply saying that? Why, you're right for both. Why couldn't I have been prosecuted for either? Mm-hmm. Yeah. Yeah. So, I mean, let's look at our framework, right? Is saying fuck the draft or fuck the flag, is that protected speech, Marianne? Why? Give me the easy answer. What category does that fall into? This is what you need to do for the exam. Why is protected speech? What category does it fall into? It's right here. Oh, okay, fine. Fair. Madison. Okay, what category does it fall into? Does it fall into an unprotected category? So is it protected speech? Okay, so we know that, fuck the draft, fuck the flag, those are protected forms of speech, right? But there was a law professor at Ohio State who wrote a book called Fuck, and it was massively controversial. It was actually about this topic. And he says that words have such power, and people are afraid of words, and I want to push back against that. Words do have power. We should embrace them. So, it's protected speech. Is it content-based, Madison? When you arrest someone for saying fuck the draft, is that a content-based restriction? Well, why is the person being arrested and prosecuted? What did he say? You have to say the word if you don't want to. What was he criticizing with his message? And so what was this a content-based prosecution? Why? Yes, why is it content-based? Why is he going to jail? What is he being thrown in jail for doing? Yes, he is being sent to jail for the content of his message. Everyone understand that? He wasn't just saying fuck, right? He was saying fuck the draft. He was going to jail for the content of his speech. That is a content-based restriction, which is afforded strict scrutiny. Game over. He wins, right? So had he said the exact same message, instead of burning the draft card, he said fuck the draft, he would have been fine. Daniel, why does this case, why does O'Brien come out differently? What did the court say in O'Brien?
Well, they made a difference between simply speaking and doing something. And so they said there was a distinction.
What's the distinction?
It wasn't like in that other case where he said he actually did something.
Good. Okay, so we have this distinction here, right? So we have speech and we have expressive conduct. So it goes without saying, just saying, fuck the draft, speech, I can say it till I'm blue in the face, right? But rather than actually saying it, he decided to engage in some sort of action, which is expressive conduct, or we can call it, a speech act, if that makes it easier for you to remember. A speech act. Okay, what is this speech act that he's engaging in? He's burning the card. Okay, so it's undisputed that he was being arrested and prosecuted for burning the card, right? Luis, was arresting this guy for burning his draft card, did that infringe on his free speech rights?
Well, the court ruled that it did not.
No, but did it have any effect on his free speech rights by arresting him? What do you think? Do you think he'll ever, again, after this case, go and burn the draft card again? Why? Exactly. The fact that the government is arresting people for draft card burning means people will modify their behavior, right? No one wants, well, not everyone. Most people don't want to go to jail, right? This chills speech. It inhibits speech. If I want to engage in this act of draft card burning, I'm going to think twice because I'm going to go to jail. Okay? So if this speech is so important, Ryan, why was the court okay in sending Mr. O'Brien to jail for it?
Well, like Daniel was saying earlier, it's basically the act itself is what they were prosecuting for.
What was the rationale? What was the government's motivation
Well, they said that
behind draft card burning?
They said that burning the draft card would basically mess up the efficiency of setting up, and maintaining an army or militia, and that they had this process to keep these cards on your person for just, basically mainly efficiency, and that the government interest in that.
Exactly.
Totally effective.
Exactly. This was the age before the internet, right? All we had were paper records. And I'm sure every man in this room, or at least if you're an American citizen, when you turn 18, you register for the Selective Service. I did it. I think probably everyone hopefully did it as well. At the time, the draft was in effect. And when you register, they sent you this card. You were required to keep this card on you at all times. This is why if a member of the military found you, they could say, okay, son, where's your card? And if you didn't have it on you, they could arrest you. Okay? This was a means to make sure that people didn't dodge the draft. This was a huge problem in the 60s and 70s. People were dodging the draft. So this card was actually necessary to, as he said, to enforce an effective military. Okay? So everyone gets it. So the stated rationale, right? This wasn't about limiting speech, right? This wasn't sort of content-based restriction. It was actually content neutral, right? It's like, we don't care what your message is. Just keep your card in good order so we can manage our military efforts. You learn?
So does the law already exist that says you can't tamper with your draft card? Or if it did it not exist already, so then you're kind of being...
So here is the important thing, right? Here is the huge elephant, maybe donkey in the room that no one was willing to address. The law was modified in 1965 at the peak of the Vietnam War. And Representative Mendel Rivers, this was in the notes afterwards, introduced a bill to make it a crime to destroy a draft card. Okay, what was his statement? This is a clear answer to those who would make a mockery of our efforts in Vietnam by engaging in the mass destruction of draft cards. He said, burning draft cards is treason. Whoa. So the court just went and made this entire lengthy discussion how this is actually necessary for an effective military system, right? But in the background, we have this legislative history where they're saying burning draft cards is treason, and we can't have people making a mockery of our war efforts. Is this content neutral, William? William, is this content neutral where the people voting on this law are saying, let's do this so that these hippies can't make fun of our war, and that these, these treasonous, Utes, as they say in Alabama, right? How do we deal with them?
Content based off of protesting the war.
But on the face of the law, right? If you look at the face of the law, does it say anything about hippies on the face of the law?
It does not.
What does it say?
You can't burn or mutilate.
So this is actually a tricky question, right? If we look at the face of the law, it's neutral, just as you can't burn your draft card. But if we look at the history of the law and the time in which it was passed in 1965, right? It was clearly meant to punish hippies who were opposing the war, draft dodgers. Is the court willing, Brett, to invalidate a law based on whatever purpose is underlying it?
They said they would be if that was the only purpose, but
Good.
because just one person or a few other congressmen expressed that view, that wasn't enough.
Exactly right. The court wasn't stupid, right? They lived in Washington, D.C. They saw the protests every day. They knew what was going on. Saying, listen, we know there's probably some sort of illicit motives, but we're not going to strike down this law because some people maybe had bad motivations. So long as there's a good reason why the government could have done this, we'll uphold it. What does this sound like, right? Rob, what kind of screaming does it sound like where they ignore the actual reasons for the law and they find a way to uphold it? What does it sound like? You've done this before. Oh, this is not strict. They're basically pretending they don't know the real reason for a law. What does it sound like? I think you whispered it. Rational basis, right? And we discussed this, rational basis. Where the government pretend they don't know what's actually going on. Say, well, here's, on its face, this looks fine. Here's a valid reason why it could have been done. Let's do it, okay? The time, place, and manner, this content neutral deal, like in O'Brien, is not exactly, but it's similar to rational basis. It's not exactly, but it's akin to rational basis. They'll let the government say, look, here is why we did this. This might not be the real reason, but it's close enough. So in the end, they upheld the burning of the draft card. So you have it. I can say, fuck the draft, but I can't burn my card to make the point. Right? I can use my words, but I can't use actions to burn it. Okay? With me so far. I'll point out, very interesting, Justice Douglas. Justice Douglas was insane. I'll tell you why in a second. In 1973, there was a court case brought where a bunch of people said that the president's bombing of Cambodia was unconstitutional. A federal court in New York enjoined the bombing of Cambodia. A judge told the president, you can't bomb Cambodia, it's illegal. This is how crazy stuff was back then. Freaking nuts, okay? So, get this chronology. The Second Circuit Court of Appeals said, are you insane, judge? They put the judges on hold, right? Then this group appealed to the Supreme Court. They go to Justice Marshall, who is the circuit justice for the Second Circuit. And Justice Marshall said, are you freaking insane? And he said, stop, you're not doing this, right? After Marshall said no, they tracked down Justice Douglas by himself. And Justice Douglas, on his own, without telling anyone, put the war in Cambodia on hold. On his own accord, by himself, he said, this war is unconstitutional. I'm not going to let you do this. Within 2 days, the entire Supreme Court voted against him. You are insane, Douglas. Go have a drink or something, right? And they let the war proceed. So Douglas is nuts. So what did he dissent? What's his dissent? This was not a legally declared war, therefore there can't be a draft. He wasn't even addressing whether the draft got. He said, you can't even have a draft because there's no declared war. He was nuts, okay? This guy tried to run for president several times in the Supreme Court. Wacko. But he was such an environmentalist, okay? He once was hiking somewhere and he needed like directions. He wrote a letter to the Secretary of the Interior asking for like highlights of a national park. Guy was loony. He was the one who married like three of his secretaries. He divorced them every decade or so. Guy was a nut job. Anyway, so that's Justice Douglas. So we have O'Brien saying that you can say fuck the draft, but you can't burn it because that's a valid content-neutral regulation, and the government can regulate the manner in which you hold on to your documentation. Everyone get O'Brien. Everyone get O'Brien. Connie?
I'm just trying to understand on how you do the speech information. So the rational basis reading of the law that they're looking at, that's why it can be in strict scrutiny because it's not.
You were correct. Say that again. You were correct,
I
and you.
I have it in my brain to even ask the question.
Okay.
Like, I'm trying to figure out what. I think I understand why rational basis goes in the content-based strict scrutiny section of the speech part. It's because it's not a strict scrutiny law. It's rational.
Let me walk you through this again. So I think you're dancing around. Okay. And again, I am oversimplifying. If you notice, I didn't even bother giving you the 4-factor test from O'Brien, so it'll confuse you even more. So let's just stick with this, right? You have to ask initially, is this a category of protected speech? If you're dealing with child pornography or obscenity or something like that, no protection, no scrutiny, right? None. It can be banned. Is it some sort of protected speech? Basically everything else. If the answer is yes, you apply some kind of scrutiny. Now, how do you decide if it's going to be strict scrutiny or rational basis? You ask yourself, is this a content-based restriction? Is it based on the content of the speech? If the answer is yes, you give strict scrutiny. If it's some sort of content-neutral speech, for example, the sound truck or the speaker system, that's content-neutral, then the government can regulate time, place, and manner. And this is effectively like a rational basis review. Basically, if the government has some good reason why they can do it. This is not a complete map of the First Amendment, but this will get you most of what you need for this class. You can take, I encourage you, there's an entire class offered at this school on the First Amendment. If you like this, take it. I give you 2 days on it, which not, you can take an entire 3-credit class on it. I'm giving you 2 days. That's it. Yes, ma'am.
So if we have a question concerning this,
I'm not going to say that, but if you get this, I'll be happy. The problem is there's like 20 different First Amendment tests. We're only doing a handful of them, so this framework will get you to where you need to go. Okay? Let's consider another example. Austin, let me ask you this question, right? What happens if there's a group, right, and they're an advocacy group for homeless people, and they're trying to demonstrate how much homeless people suffer in society. And so what do they want to do? They want to hold an overnight protest in Lafayette Park across from the White House. They want to protest overnight and sleep in tents across here from the White House. And they're doing this to try to explain to the president how homeless people suffer. And they do this.
lesson? Is it how do they do this?
Can the government ban them from using this form of protest? Walk through the framework. Walk through one step at a time.
So I think
Is this protected speech? Is engaging in a protest to discuss supply of the homeless, is that protected speech? Okay, it is, right? Okay, so then what do we do?
So then you have to figure out whether the government is trying to regulate what they're protesting.
Yes.
Or whether they're just regulating the manner in which they're
Right. So let's say the government says, we'll give you a permit to protest from 9 to 5, but you can't protest after sunset. Why is that perfectly fine?
Because they're not regulating what the homeless people are protesting, they're just regulating the manner in which
The time, place, and manner, because it's content. Exactly. That's what you have to do, right? That's the framework, right? You say, is this protected speech? Yes, they're discussing homeless people, politics, whatever, important stuff. Is the government censoring on the basis of speech? No, they're saying simply, you can do this, but you can't do it at night because it's dangerous, and national parks are closed at night, we don't have security, whatever. They're valid reasons. They're not trying to stifle the speech.
Okay, so with people protesting, say the homeless in your demonstration, if they said, okay, we're going, you can protest, hold your protest, but it's got to be on the other side of town, which would completely put effectiveness and they're doing that because they don't.
Okay, good. So Vicky's question is like this, right? Say they're trying to send a message to the president, and they say, we want to hold our protest across the street from the White House, right down Constitution Avenue, right in the middle of Washington, D.C. Okay, and then C says, no, we can't shut down traffic on this major street in the middle of rush hour, right? They say, we want to do it on Monday morning at 9 a.m. Would that be a valid restriction on the manner and place and time? I think the answer to that question is, do they offer other parades? So let's say every other group was allowed to do a parade in that exact spot on that exact day, but they tell this group, sorry, we can't do it. That may be suspicious, but we do not allow it. So that actually happens to address Vicky's question, is that cities have pre-approved routes. They have pre-approved times for parades. They have pre-approved parade routes. And they say every parade, I mean, if you saw the Go Texan parade a couple weeks ago, it goes right down, right? Every parade used to provide a similar path. If you want to have a parade, that's the path you have to choose. And by keeping it neutrally limited to everyone, they're not discriminating.
What if the parade or the protest being overnight is essential to your message? So then in a way, like, you're releasing
The Vampire Coalition, right?
Yeah, or or you want to raise
Light
awareness.
sensitivity awareness, I don't know.
Right, or light blindness, or I mean, I thought of that. It sounds silly, but I thought of it because of homelessness. It's a little bit more poignant to.
So generally speaking, the manner, part of time, place, and manner, and the time, courts have upheld things during daylight hours, and that may have an incidental effect on some, night walkers, whatever.
Yeah, or
But
if you wanted to say like, I want to try and bring awareness about homelessness, but like homelessness doesn't exist like just from 9 to 5. We want to talk about
so if you read the O'Brien case carefully, I think I did the test. It says, is there an incidental effect on speech? Yes. Is it more than incidental? Then we have a problem. Yes.
Just while on the subject of protesting, a little less about scrutiny, more please into the last class. How does protesting come into play with the fighting words? Because I think about the Westboro Baptist Church.
Good. It's not every felt, yeah.
Their protests, to me, seem like way more fighting words than.
Okay, so everyone know about the Westboro Baptists, right? These are a group of people that protest funerals. They basically say that, God hates, everything. Like, God hates everyone, right? And because of everything you're doing, God hates you, okay? One interesting thing about Snyder Phelps people know is that they protest very far away. This is not actually documented, but they're usually very far away from the funeral. In fact, people at the funeral, in that case, never even saw them. They only saw it on TV later. So it's been very hard to claim fighting words when you only see it on TV later. And actually, they're very deliberate about this because they know if they stand right next to the funeral with their sign, number one, they're trespassing because the funeral is private property. And number two, they may have a fighting words list, so they can knock them out. So they're actually, Snyder Phelps was argued by Margie Phelps. She was a lawyer and member of this clan. And she did a terrible job. But they're not totally stupid, right? They have some knowledge of First Amendment law, which they try to adhere to. But let's talk about fighting words, right? Let's talk about the next case, Texas versus Johnson. Hugh, we have a case where a guy starts burning an American flag in the middle of Dallas during the Republican convention to protest politics. I see that's how you busted your arm, so you knocked him out, right? You punched him? So if you were standing there, Hugh, right? You were standing right next to this guy burning the American flag, and you're a patriot, you're a red-blooded American, right? Could you have knocked the guy out in the fighting words doctrine? What do you think?
Well, this court says no.
Right. So to Jonathan's question, what if you saw someone burning the American flag and you are a patriot, you fought in the war, your grandfather fought in the war, your great-grandfather fought in the war, I mean, you were born on the 4th of July, right? Right? Could you knock this guy out? And the dissent in Texas for Johnson says, yeah, these are fighting words. But in this case, no one knocked him out, right? In fact, one guy actually picked up the remains and buried the ashes of the flag. So, Christian asked me before about the obscenity doctrine. I told her it doesn't really apply anymore. I would put similar weight on the fighting words doctrine. I don't think there's been any case, in my lifetime at least, where the court has upheld a conviction based on the fighting words doctrine. It doesn't really apply anymore. And I'm not saying it doesn't exist, but it's been weakened down that it almost doesn't even matter anymore. So, Jonathan, not to discount your question, but the fighting words doctrine is on its way out. So how come, Rob? I'm sorry, Luke. Luke, how come it's okay to burn a flag, but it's not okay to burn a draft card? How does the court square those? Yes. Why was this law content-based? What was the difference between the law in O'Brien and the law in Texas versus Johnson? Okay. And what did the statute say in the Texas case? And what did it actually prohibit? What did it criminalize? You're overthinking it. What did the law criminalize in Texas? No, specifically, what act did it criminalize? Yes. Okay. The law in the Vietnam case in O'Brien said you can't mutilate or destroy your draft card because it's important for the registration purpose. The Texas law said you can't burn a flag because it disrupts the peace. Okay. Shelby, was this content neutral? Was this saying that we don't want to have a breach of the peace, so don't burn your flag? Was this a content neutral restriction? Yes, exactly right. This was not content neutral. It was specifically saying you can't do this one very specific thing. This very specific thing of flag burning, you can't do. Right? Shelby, was there any prohibition on breaching the peace in general? Could the state say you can't disturb the peace? No, say this in general law saying you can't have a disruption in public. You can't, disrupt public. Is there anything wrong with that? Is that a valid law?
It's not content based.
Yeah. So if it was a general law, right? If it was a general law that said you can't disturb the peace, that law's fine. But Lauren, what did this law do specifically?
It said you couldn't disturb the peace by running.
Yes. It singled out a specific manner of disturbing the peace, a very specific manner of burning a flag, right? It didn't just say, if you're disturbing the peace, whatever, you can be arrested. It singled out one very specific act that has a lot of expressive conduct. Use this word we used before. A speech act, a lot of expressive conduct, which was flag burning. Right? So Jonathan, what did the court hold? Was the statute valid? Did the court see this as a content neutral time, place, manner regulation? What was it?
It was.
If it's not content neutral, what is it?
Content based.
Exactly. Go through this framework. I promise you, it'll help you. I'm not giving this for my own health. It's not content neutral. It's content based. Therefore, you apply something approaching strict scrutiny. And the government does not have a very good rationale for doing this, right? They may have an interest in protecting the public peace, but they can do this in a more narrowly tailored way. They can have a statute saying, if you disrupt the peace, we'll arrest you. But this was targeted at one very specific act. Okay. Plowman, doesn't the state have a very compelling interest in protecting the flag? What does Justice Brennan say in the majority? Doesn't the state have a very strong interest in protecting the flag? Yeah, my country, 'tis of thee, sweet land of liberty, right? Why can't the state of Texas protect the flag? Plowman, what is it about burning the flag that the state of Texas didn't like? Why didn't they like when people burn flags?
Well, they think that it's because it inside into the piece, but
What were they really trying to do here? What did they find? How did they do flag burning?
they thought it was, I don't know, they thought it was, they didn't agree with it, I guess.
Because it was offensive, the O word, right? What do we say about offensive speech? Protected. The mere fact that something's offensive or what millennials think means it's still guaranteed First Amendment protection, right? Offensive speech is protected. Please don't forget, if you learn nothing else, when you remember that, because people don't remember that today. Yes?
I just have to say, this case when they forgot
I still have to learn the Texas Pledge of Allegiance. I really need to learn it one of these days. I know, it's short. I promise I will learn it. So, the majority says you can't ban speech because it's offensive, right? The mere fact that, Megan will start shooting, or Jennifer will start shooting people who are burning the Texas flag, that means you disagree with it. That's more the reason why you can't regulate it. You can't regulate speech that you disagree with. You can't regulate speech that's offensive. Okay? And then Justice Breyer's entire missive at the end saying, well, you know what? The American flag represents liberty so much that someone's burning it, we should salute it, right? That the flag is so important that we should respect it and honor it and not try to oppress speech in the name of the flag. And you might not agree with that one. Yeah.
About what happened at
UC Irvine. Oh, what are we talking about?
this past week, we had an issue like this. There was a protester on a university campus. They were walking across the flag on the ground, and former Navy, I don't know what her position was, but she was stealing a flag from the protesters.
Oh, I saw that, yeah.
Waiting like 6 minutes trying to
Run away.
Yeah, not be arrested, basically.
So you can't steal, right? As much as the American flag represents free speech, it represents property rights, and you can't steal someone's stuff. I thought the case you mentioned was at UC Irvine, where the student government voted to remove the American flags from the school because they found it too offensive, which is also an interesting one. Yeah.
What do you think about the constitutional challenge to the license?
Okay, I didn't discuss it before. So Texas had. I'll try and do it briefly. I'll get you a second word. Texas has a policy that basically says if any organization comes to Texas and they have a design for a license plate, it'll be granted. So you get like a Dr. Pepper license plate, right? Or Texas A&M or whatever it is. So the Sons of the American Confederacy, or the Sons of the Confederacy, came to Texas and we want to make a flag on the license plate with the Confederate flag on it. Mind you, Texas celebrates Confederate History Day and Robert E. Lee Day and Jefferson Davis Day. These are state holidays. The good folks at the Department of Motor Vehicles, whatever it's called, said no, we find this offensive, and they denied the plate. This case is now on appeal to the Supreme Court. I think Texas is probably going to lose this one. And if you have a policy where you say anyone who wants to have a license plate can have one, well, you can't pick and choose. There'll probably be a dissent on this point too, but the fact that it's offensive doesn't render it unprotected. But I can be wrong. Morgan?
So do fighting words have to be directly geared to, like your speech act has to be directly geared to a specific person?
Yes, but again, Chaplinsky is not really very good law anymore, and when we do Brandenburg, you'll understand why. Brandenburg law gives the plan to Chaplinsky. Yeah. Well, if you want to get recent, Oklahoma, right?
Yeah.
The school acted unconstitutionally. Terminating a student for using the N-word is unconstitutional. Absolutely unconstitutional. I don't think they'll sue because they don't want to drag themselves through the mud, but you can't terminate a person from a public institution for cursing and using words that are unpleasant. You can't. That's what I'm saying. Offensive words are protected, and this is something which today's generation has no interest for. The school made this, I think, weak argument that they create a hostile learning environment that really forgets the fact that the First Amendment trumps any sort of statutory arguments in their favor. So, yeah, I mean, you can't do that, as bad as it is. Let that person be shamed, let him withdraw, let him be humiliated, but the school can't expel him. Yeah.
Back on the Texas v. Johnson, don't most, or at least some states have like anti-flag desecration laws, but if they're burning it for politically, like.
So to be precise, states have laws about the proper method of burying flags, but if you fail to comply with them, they can't arrest you for it. In other words, states and the federal government have a proper method for disposing of flags. You're actually supposed to burn it and bury it. That's the correct method of flags carried, right? But if someone does it in a political speech, they're not getting arrested. That's unconstitutional. So the year after Texas v. Johnson, let's talk about amendments, right? There was discussion of a flag burning amendment to amend the Constitution to ban flag burning. Basically, would carve out the First Amendment. To avoid the amendment, what they do? They passed a statute, similar to DOMA, right? Remember I said DOMA was passed to avoid a marriage amendment? This law was passed to avoid a flag burning amendment. The flag burning amendment was, the statute was facial and constitutional. The court had just held that you can't ban flag burning. Congress passed a statute saying, we ban flag burning. Within a year, it was challenged in court and was invalidated by the same 5-4 vote. Okay. Any questions on the flag burning case? Yes, Hector?
I have one more question. On the projector, it says if it's protected, there's some scrutiny. And then right below, if it's content-based, it's strict scrutiny. Shouldn't they both be strict scrutiny?
No, because it can be protected speech that's content neutral.
Okay.
Right? That's why I said some. So it's either here. I'll state this clearly. Right? If it's content based, then it's strict. If it's content neutral, it's I'll say time, place, and manner. There's also intermediate, but I'm not even going to bother. I don't have nearly enough time in this class. There is actually a intermediate category which I'm not even going to bother teaching you because it gets even more complicated. There's also commercial speech, which I mentioned at the end very briefly. Okay. Let's talk about Renton versus Playtime Theater, a very aptly named case. In case you couldn't tell, Playtime Theater was a oh, let's do Brandenburg first. I'm sorry, I skipped. Oh, did I do? Yeah, Brandenburg comes next, right? Oh, Playtime. Sorry, Playtime. So Playtime Theater, in case you couldn't guess, is an aptly named porno movie theater. So before the internet, people wanted pornography to go to a theater. That's how the world worked before the internet. This way back when. So where was I up to? Lauren, perfect. Lauren, is running a porno theater protected speech? You were next. I don't rig the process.
I think it is.
Whose speech? Is it the right of the actors in the movie? Is it the right of the film distributors? Is it the right of the movie house owners? Is it the right of the guys watching the theater? Who's?
A lot of people.
All the above. I think that's the right answer. Right? Displaying a movie represents a lot of speech interests. The actors, the producers, the directors, the people who are running the movie theater, the patrons, right? Everyone is involved in this speech act. Even though it involves naked stuff and whatever else, it's still protected. Lauren, could the city ban pornography theaters? Period. Okay. If the law passed said no pornography theaters in city limits, that would be a content-based restriction, and under strict scrutiny, it would fail. Okay. So let's see. Michael, let me ask this question. What if instead of banning pornography theaters, say, okay, we're just going to regulate where they can be. And we're going to say you can't have any porno theaters within 1,000 feet of any residential area. Why is that different?
call their secondary effects.
I don't get this. You're exactly right. But why is it different to regulate where they can be rather than its existence?
It's not based on content.
What is it then? Okay, so the argument is we're actually not regulating the content of the theater. It's content neutral. We're saying, okay, you guys can exist, but you can't exist near residential areas. Sarah, perfect. Is this actually content neutral? This is a question I asked before. Is it actually content neutral to say that any pornography theater can't be within 1,000 feet of a residential zone? Is it actually content neutral? Oh, no, let's not get into the interest. But on its face, is this law content neutral, content based? Just on the face of the law. Okay. Tell me, what do you think?
I think it's content based, because even though they're saying it's because of zoning laws and things like that, it's really because of the content they can't use in the residential area.
Okay, so this is the divide between the majority and the dissent, right? The majority says this is content neutral, right? It's not saying you can't have a pornography theater. All it's saying is that if you have one, it can't be near a residential area. The dissent saying, oh, no, this is not right. If I want to open up a regular movie theater to show Disney movies, I don't need any permission. If I want to open up a theater to show, Shakespeare, right? I don't need any permission. But if I want to show a theater with pornography movies, then I need to go through this entire process. Okay, so what Sarah's asking, that's this, right? If you ever look at a map of a city and you try and draw a circle and say, okay, I can't be within 1,000 feet of a school, a park, or residential area. There are virtually no areas left to build. And as noted in the opinion, the only areas that were left to build were not even zoned. They were zoned for industry. Did you do zoning yet? No. So the way zoning works in different areas, right? So you can have residential, industrial, commercial, right? A movie theater can only exist in a commercial zone. What if the only areas left in the entire city to build that were not within 1,000 feet of a home were industrial? Then you can't build anywhere. So whenever you see a law saying you can't build within 1,000 feet of X, that's saying we're going to ban it very quietly. Did I tell you the story about the methadone clinic? So when I was clerking at this one case involving a methadone clinic, right? And the city said, you know what, we can't have methadone clinics with all the secondary effects, all these people coming in, these vagrants, whatever, drug users, we don't want them coming to our town. So it passed a law saying you can't build a methadone clinic within 500 feet of a school, house, park, church, whatever, right? Okay, so they actually found one place to build it. It was on the outskirts of town in the total opposite end of the neighborhood, right? And they said, we're going to build it here. It was nowhere near anything. What did the city do? I swear. They designated the strip of grass in front of the building a park. They said that this little strip of grass in front of the methadone clinic was a park, and they can't build it there. This was not a First Amendment case, but you see the idea. Basically, they try to zone things out of existence. Happens all the time. For sex offenders, this comes up a lot. Sex offenders can't live within 1,000 feet of a home, school, park, whatever. In some cities, they have nowhere to live. So in Miami, they're living underneath the highway underpasses because it's the only place they can legally live. You used to tell me. So what happens here? Well, the court says, majority says this is content neutral, and therefore because you're policing the secondary effects, they're not policing the speech itself. They don't care about pornography. They care about all the dangerous things that come with pornography, like all those guys who watch pornos, those dirty old men, right, who come and they commit crimes, right? Because the state has an interest in regulating these secondary effects, they can decide where to place these pornos, okay? So the court upheld this, they valid time, place, and manner rationale. Okay, any questions in this case? You'll do zoning next semester in property too, and this will make a little bit more sense, I think. Okay. The last case I want to talk about is the one why Chaplinsky doesn't really matter much. And that's the case of Brandenburg versus Ohio. Okay, Brandenburg versus Ohio presents these facts. You have a Ku Klux Klan rally in Ohio. Okay? A KKK rally in Ohio. And they invite some reporters from the local news station to come and film it. Okay? So this wasn't live. This wasn't like they were inciting people. They weren't. But they were trying to record a message. And on this message, the Klan rally says, you know what? We're gonna get revenge for the white race. The Klan will march in Washington, D.C. on the 4th of July. We have 4,000 Klansmen in hoods and everything. And after that, we're going to branch off and march to Florida and march to Mississippi. And he sends by saying thank you. Okay? This is then broadcasted on the news. The police then arrest the Brandenburg, the Klan leader. On what basis do they arrest him? Well, it wasn't for leading a march in Washington. He didn't actually do it yet. It wasn't even on any planning for the march in Washington. They had no evidence this was a real thing. I don't think it ever actually happened. Instead, they arrested him on the basis of his speech. And they said that his speech was basically advocating a violent act. So the question is this: can the government punish speech that advocates violence? Can the government punish speech that advocates the overthrow of the government? So there are a number of cases from World War I, which I recommend you mention, read in the books. It was Debs, Frowork, and what's the other one? Debs, Frowork, and Schenck. Yeah, Schenck, Debs, and Frowork. These were 3 cases decided in World War I, decided within like a week or 2 of each other. And these cases involve basically punishing people who spoke out against the war. So people who spoke out against the draft were arrested. Remember I said, fuck the draft protected? Back in the year 1917, it wasn't. And you could basically arrest someone for handing out a pamphlet opposing the draft. You could arrest Eugene Debs, who was a socialist candidate for president. You could arrest a newspaper man who was trying to publish a socialist newspaper. Okay? All these cases said that the government has an interest in punishing speech that promotes violence. Brandenburg reverses those cases. Brandenburg reverses those cases. What does Brandenburg say? You can't punish speech just because it promotes violence. You cannot publish speech just because it promotes violence. Okay? You need to have speech, and this is the Brandenburg test, right? Brandenburg. That has an inciting or producing imminent lawless action and is likely to incite or produce such action. Okay? The mere fact that your speech has the effect of advocating for violence, marching on Washington to the KKK, that speech by itself cannot be criminalized. Only if your speech incites imminent. The key word there is imminent. Only if your speech incites imminent violence. I'm talking about right away. There's a mob outside and you are riling them up. You're saying we need to do this and do that and do this and burn that, right? And then a riot ensues. Only in those limited cases can the government criminalize your speech. But a person cannot be arrested for doing a pre-recorded message at a rally saying what we're going to do next week. That is not imminent, even though it is violent speech. So inciting people to violence, inciting people to overthrow the government, inciting people to join the Socialist Party, whatever it is, all protected. But you can't make someone incite an imminent riot. Okay. Questions on Brandenburg? Yes, ma'am.
So the moment they started marching, would that be imminent?
So let's say another example, right? Let's say they're standing at the rally and they're in the middle of, downtown Cleveland, wherever they are, and the KKK leader gets up on the top of a car and starts shouting, we need to burn down Cleveland, we need to fight for the whatever, and then they start rioting, start making all this mess, right? Then he can be prosecuted. The key has to be imminent. right? It can't be, let's riot tomorrow, right? No, that doesn't work. It's in the moment. It's the passion of the moment.
So when it happens, we consider that regardless of the situation.
If his words, right? If his words were likely or actually produce that action, then yes. But it has to be very soon. It can't be like, let's go riot next week, and the next week they riot. That's not going to cut it. That's protected speech. Any questions? Have a wonderful day. Oh, yes. Going once, going twice, Elliot. Either. Okay, any other questions? I'll see all of you on Thursday. Thank you. Thank you, sir.